are going to look at the last source of laws applicable in Uganda, which is customary law. So that word comes from the word customs. So customary law is unwritten law which governs the behavior and conduct of people of a given society. So these are laws that govern society, like the traditions. We can call them traditions, like the way they tell you Baganda people don't do this and that. Yeah. So it can include things like the marriage customs, things related to bride price, polygamy. It can include burial customs and very many other things. So these are the laws that govern the conduct of people in a given community, and it emanates from customs and use of such customs for a long period of time. Customary law is unwritten source of law in Uganda. Section 15 of the Judicature Act, Chapter 13, permits the High Court to apply customary law as long as it's not inconsistent with natural justice, equity, and good conscience. So the court is allowed to apply customary law when it's making decisions. So customary law is limited to civil matters and does not apply to criminal matters. Civil matters, it's where people just have disagreements and they are seeking a solution from court. Maybe like they were in a contract and one of the parties didn't fulfill their obligations according to the contract. That is a civil matter. But for criminal matters, it is something that is related to an offense, a crime. Someone stole, someone murdered, someone raped. Those are criminal matters. So customary law is only limited to civil matters when they are solving disagreements between people. Yeah, but it does not apply to criminal matters whereby someone stole, someone raped, someone murdered. So their customary law does not apply. So customary law should be compatible with written law. It should not be inconsistent with written law. It should be consistent. They should match. So let's look at the criteria that must be met by customs for it to qualify to be, must be met by a custom for it to qualify as customary law. First is that it must be in existence with uninterrupted and harmonious application, which should have dated from time immemorial. Like that custom should have been in existence for so long in that no one remembers when it started. If someone remembers when it started, then it does not apply as customary law. For example, if the custom just started in 2020, it does not apply. So it must have started long time ago in that no one remembers when it started. Then secondly is that the courts will take judicial notes of the custom because of its fame or notoriety. So if a custom is widely recognized and has been proven in court multiple times, courts can accept its existence without needing additional evidence every time it is cited. For example, if a community has a well-known practice of settling disputes through elders, the court will accept it as a valid way to resolve conflicts without needing further proof, since they know that they have been doing it previously to solve disputes between parties. Then thirdly is that customary law only applies in civil matters. When there are disagreements between two parties, it does not apply to criminal matters when someone has committed a crime. Then another point is that it only applies where it has not been excluded by parties, whether by express of contract or by the nature of the transaction in question. So the custom applies only if the parties involved have not specifically agreed to exclude it through contracts or agreements. So if two families enter into a written agreement regarding the terms of a marriage, that states that they will not follow customary marriage practices. Those customs cannot be enforced since they already included it, like they do not want to follow it or they do not want to use it. So there it does not apply. Another point is that it must not be repugnant to natural justice, equity, and good conscience. The customary law must not violate the principles of justice and fairness. They must make sure that it is fair in a particular circumstance. Then lastly, it must be consistent with the written laws. So that is the criteria that is to be followed for a custom to be applied as customary law. Yeah, and that was the last source of laws applicable in Uganda. Thanks for watching. Do not forget to subscribe, like, comment, share with your friends. Let's catch up in my next video.